My name is Nate Meyer. I'm a partner at Jaburg Wilk. One of my practice areas is insurance, including insurance coverage advice and litigation, insurance bad faith advice and litigation, and insurance UM/UIM litigation. A Morris agreement is a settlement agreement between an insured and a plaintiff in which the insurance company has provided a defense, but they've done so pursuant to a reservation of rights. In a Morris agreement, similar to a Damron agreement, the plaintiff will stipulate to a judgment with the insured. The insured will assign any rights that it has against its insurance company to the plaintiff, and the insured will get a covenant not to execute that stipulated judgment against the plaintiff personally. An insured has four basic defenses to a Morris agreement. That's notice, reasonableness of the stipulated judgment, coverage, and again, fraud and collusion. Regarding notice, Arizona case law is very clear that an insured and a plaintiff, they have to put the insurance company on notice that they are going to enter one of these types of Morris agreements. And it has to be reasonable notice. Exactly what reasonable notice is in terms of the amount of time, is it 10 days, is it 2 weeks, isn't really clear in Arizona case law. What is clear in Arizona case law is that the insurance company needs to be presented with a clear choice. They have to have a choice of either pulling their reservation of rights and providing an unconditional defense to their insured, or letting the Morris agreement go forward, and then they know that their defenses are going to be limited to coverage and the reasonableness of that stipulated judgment. Another defense to a Morris agreement is coverage. If it ultimately turns out that the claims on which the insurer reserved their rights are not covered, then that Morris agreement is not going to be enforceable. Another defense to a Morris agreement is the reasonableness of the stipulated judgment. Unlike a Damron agreement where a plaintiff and insured can essentially stipulate to a $2.5 million judgment on a claim that is actually only worth $100,000, in a Morris agreement, that stipulated judgment has to be reasonable. So, and an unreasonable stipulated judgment doesn't completely void the Morris agreement, but the Morris agreement is only enforceable to the extent it's reasonable. And the way you determine whether it's reasonable is there's something called a reasonableness hearing at which the insurer, he would intervene in the litigation, and then they would figure out whether that was a reasonable amount to settle that claim for. The last defense to a Morris agreement is, again, fraud and collusion. Just like in a Damron agreement, Morris agreements are not fraudulent or collusive as a matter of law, despite the fact that they may seem that way when you're first presented with it. And again, the standard for fraud and collusion is very high. It has to be, the insured gets on the stand and agrees to perjure himself. There's some sort of sham proceeding conducted without the court knowing about it. That's the fraudulent and collusive defense to a Morris agreement. If one of your insured goes ahead and enters a Morris agreement, then what the insurer needs to do is they need to move to intervene in the litigation between the plaintiff and your insured. You want to move to intervene so that you can contest the reasonableness of the judgment, so you can litigate dispositive defenses you have like notice and coverage. And normally how that works is you want to file your motion to intervene, and then you probably want to try to stay the litigation between the plaintiff and defendant before they attempt to execute or collect upon that judgment, so that you can litigate dispositive issues like notice and coverage. You can usually do those in a motion for summary judgment. If you lose on the dispositive issues like notice and coverage, then you want to prepare to contest the reasonableness of the stipulated judgment in something called a reasonableness hearing, where both sides come in and they present evidence as to why or why not this $2.5 million judgment was a reasonable amount to settle this claim for. If an insurer does not request a reasonableness hearing to prove up that the stipulated judgment in a Morris agreement was in fact reasonable, the insurance company still has the right to file a declaratory judgment action in which it could contest the reasonableness of a stipulated judgment in a Morris context.